Hello everyone. Welcome to Law Simple, Pure and to the Core. Dr. Vaishali here. Today's topic of discussion is Law of Torts. Before we begin, I would like to give you three examples. Case number 1. A and B are neighbors. A wants to sell his car for 50,000 rupees on 1st of Jan. B agreed to take his car for 50,000 rupees on 1st of January. Both are competent to enter into a contract. There is no problem as such in legal terms. They write this upon a piece of paper and sign this. Case number 2. A and B are neighbors. A has a dog, B owns a horse. B owns a horse. One day, A's dog gets released from his house, and while B is riding his horse and he is going on a street, this dog goes and barks on the horse. Because of that barking, B's horse gets startled, and because of that jerk, B falls down. This is case number 2. Case number 3. A and B both are friends. They go to drink some wine in a wine shop. When B has gone to a washroom, A puts some poison in the wine of B. This is case number 3. Now case number 1 falls under law of contract because there is an agreement between the parties and it comes under civil law. Case number 2, when the dog gets released out of the house and barks at the horse, it comes under law of torts because there is no intention to cause an harm, but it happened, that wrong has happened. And case number 3, intentional act has happened to kill a person or to kill the neighbor or to kill B. This comes under crimes. So there are 3 distinguished branches of law: law of contract, law of torts and law of crimes. So law of contract comes under civil law, law of crimes comes under criminal law, torts comes in between. They are wrongs, but they are called as civil wrongs. Let us begin now. Tort is derived from the Latin word called tortum, and tortum means wrong. Tort and crimes both have common law origins, and even contract has a common law origin. So if there is a question for any competitive exam, law of crime has which type of origin? Remember, common law origin. For torts also, and for contracts also, and for crimes also. Both originate in Germanic system of compensatory fines for wrongs. In India, law of torts came from Britishers, and it is shaped after the principles or in concrete case laws in Great Britain and in US as well. So it has a British origin. Tort is called as a civil wrong. So it is a wrong, but it is not a criminal type of wrong, but it is called as a civil wrong. Tort cases are ever expanding because it is law of torts and not law of tort. So there is no single code which is made for law of torts. Torts are multiple and they are ever expanding, and that's why it is law of torts and not law of tort. Objective of law of torts, as it belongs to civil law domain, objective is corrective and not punitive. For example, like in criminal law, the object of criminal law is to punish the wrongdoer and to set a lesson in front of society. But in case of civil law, object is to correct the wrong which has happened and to compensate the victim. So objective of contract and tort law is not to punish a wrongdoer, but to correct a mistake which has happened. Types of torts. Torts are of 3 types basically: intentional torts, negligent torts, and strict liability type of torts. First category of torts is of intentional torts, a tort caused by an intentional wrongful act by the other person or group of person. For example, assault, battery, trespass, false imprisonment, slander, or libel means writing something bad about somebody. So these are intentional types of torts. Torts are less serious than crimes, so punishments are also less severe. Second category is negligent tort, when there is no intention to cause some type of harm to somebody, but harm happens. For example, dog gets released from a house and goes and bites someone, or a milk bottle is given to a baby and that bottle sometime bursts or some injury happens to the baby, but there is no intention to cause the harm, but some carelessness is there or some negligence is there, so they come under negligent type of torts. Third type of torts are called torts under strict liability. In these types of torts, a person is considered to be liable irrespective of his intention to commit the wrongdoing. These torts are such as they are of strict nature, and even if there is no intention to cause harm, still liability is imposed on the person. Okay, so these are three major type of torts, and these are covered under the law of torts. Law of torts is a very interesting subject, and there are very interesting and funny type of case laws. They are there in torts laws. For example, a drunken neighbor by mistake enters in someone else's house or enters in someone else's property, such type of trespasses. Then cases relating to all type of funny instances, those are covered under law of torts. So it is a very interesting branch of law. In India, it is ever expanding, and due to activism of Supreme Court, in lots of cases, we can definitely say that due to the contribution of judicial activism, category of torts is expanding in India, and more new torts are recognized. So stay tuned till my next lecture on law of torts, and please leave your feedback and comments in the comment section, and please let me know which type of topics you want to learn, or please provide me the topic list for that matter. So till then, goodbye and good luck.